state. It means in matter of religion the state is neutral. The 42nd Amendment Act has inserted the word secular in the preamble. 42nd Amendment Act inserted the word secular in the preamble. 42nd Amendment Act has inserted the word secular in the preamble. The state treats all religions equally. The state treats all religions equally. In Usha Ben Naveen Chandra Triveni versus Bhagya Lakshmi AIR 1978, Guj 13. In Usha Ben Naveen Chandra Trivedi versus Bhagya Lakshmi AIR 1978, Guj 13, the court observed that Article 25 Clause 1 recognizes the principle. The court observed that the Article 25 Clause 1 recognizes the principle that it is the policy of the state to protect all religions but to interfere with none. It is the policy of the state to protect all religion but to interfere with none. It enunciates traditions of religious neutrality of the state. It enunciates traditions of religious neutrality of the state. The state does not identify itself with any particular form of religion, but gives equal protection to all forms. The state does not identify with any particular form of religion, but gives equal protection to all forms. Such a state differs from an ecclesiastical or theoretical state. Such a state differs from a theoretical state. It is not the concern of a state to maintain or encourage any particular religion. It is not a state concern to ensure religious freedom. It is not a state concerned state to encourage any particular religion. Its only concern is to ensure religious freedom of all citizens. It does not give any preference to any religion. It gives equal protection to all religions without encouraging or discouraging any. Its attitude is one not non-interference in religious matters. It does not mean that the state is anti-religious. A secular state is founded on the idea that the state as a political institution is concerned with social relation between man and not with relation with man and God, which is matter of personal faith. The constitutional attitude to religion in India may be briefly summarized as follows. Number 1, there is no state religion in India. State will neither establish a religion nor patronize any particular religion. There will be no state religion in India. There will be no state religion in India. Number 2, the freedom of religion is not absolute, but subject to restriction on the ground of public order, morality, and health. That means religious freedom is not absolute. That can be restricted on the ground of public order, morality, and health. Number 3, the state shall not compel any citizen to pay any taxes for promotion or maintenance of any particular religious institution. Article 27. Number 4, no religious instruction shall be given in any educational institution wholly maintained out of state funds. Article 28. Religious instruction may, however, be imparted in any educational institution which is administered by state but which has not been established under any endowment or trust which requires that the religious instruction shall be imparted in such institution. In Santosh Kumar versus Secretary Ministry of Human Resources Development AIR 1995 SC 293, it has been held that introduction of Sanskrit language as a subject in the Central Board of Secondary Education is not against secularism, as it is the mother of all Aryan language. In Santosh Kumar versus Secretary Ministry of Human Resource Development AIR 1995 SC 293, it has been held that the introduction of Sanskrit language as a subject in the Central Board of Secondary Education is not against secularism, as it is the mother of all Aryan language. Constitutional provision. Article 25 provides that all persons are equally entitled to freedom of conscience and the right to freely process, practice, and propagate religion, subject to public order, morality, and health. Article 26 says that subject to public order, morality, and health, every religious denomination or any section thereof shall have the right, number A, to establish and maintain institutions for religious and charitable purpose, number B, to manage its own affair in the matter of religion, number C, to own and acquire movable and immovable property, and number D, to administer such property in accordance with law. Meaning of religion. The word religion has wide connotation. Religion is a matter of faith with individuals. Religion lays down certain code of ethical rules for observance by its follower. The word religion has wider connotation. Religion is a matter of faith with individual. Religion is a matter of faith with individual. Religion lays down certain code of ethical rules for observance by the followers. It is not confined to religious belief but extends to various rituals and ceremonies and mode of worship which the followers of the particular religion consider necessary and conducive for the members of their community. In Rev Stanislaus versus State of MPI 1977 SC 908, the MP Dharma Swatantrata Adhiniyam 1968 and Odisha Freedom of Religion Act 1967, which prohibits forcible conversion of any person to one's own religion, were challenged under Article 25 Clause 1 of the Constitution, and court held that these acts are meant to avoid disturbance to the public order by prohibiting conversion from one's religion to another. Dealing with the meaning of the word public order, the court held that if a thing disturbs the current of the life of the community and does not merely affect an individual, it would amount to disturbance of the public order. In Rev Stanislaus versus State of Madhya Pradesh AR 1977 SC 908, the MP Dharma Swatantra Adhiniyam 1968 and Odisha Freedom of Religion Act 1967, which prohibits forcible conversion of any person to one's own religion, were challenged under Article 25 Clause 1 of the Constitution, and court held that these acts were made to avoid disturbances to the public order by prohibiting conversion from one's religion to another. Dealing with the meaning of the word public order, the court held that if a thing disturbs the current of the life of the community, and does not merely affect an individual, it would amount to disturbance of the public order. In Bijoy Emmanuel versus State of Kerala 1984, 1 SCC 615, popularly known as National Anthem case, it was held that no person can be compelled to sing the national anthem if his religious faith does not permit them to sing. In this case, three children belonging to Jehovah's Witnesses of the Christian community were expelled from school for refusing to sing the national anthem. They stood up respectfully but did not sing the national anthem. The Kerala High Court upheld their expulsion. The Supreme Court reversed the High Court decision and held that their expulsion was illegal, as there is no law in India which compels a citizen to sing the national anthem. Restriction on freedom of religion. The freedom of religion is subject to following restrictions. Number 1, public order, morality and health. Nothing can be done in the name of religion which will adversely affect public order, morality and health. In Ghulam Abbas vs. State of Uttar Pradesh 1984 1 SSC 81, the Supreme Court held that shifting of a property grave connected with religion to avoid clashes between two religious communities or sects is valid and does not affect religious right, being in the interest of the public in general. In Anand Margi case 1984, A4 SCC 522, the Supreme Court held that the Tandava dance carrying lethal and human skulls was not an essential religious right of the follower of the Anand Marga, and therefore the order under section 144 CRPC prohibiting such a procession in the interest of the public order and morality and imposes reasonable restriction on such right. An order under section 144 CRPC prohibiting such a procession in the interest of public order and morality is not violative of Article 25 and 26 of the Constitution. In Maulana Mufti Sayyid Muhammad Nurur Rahman Barkarik versus State of West Bengal, AIR 1999, Cal 15, the Kolkata High Court has held that the orders of the state government to have the use of the microphones and loudspeakers at the time of Azan is valid and not violative of right under Article 25 of the Constitution. Azan is an essential part of Islam, but use of microphone and loudspeaker are not an essential element of Muslim religion. It is a source of pollution and causes several health hazards and therefore is constitutionally valid. In Javed vs. State of Haryana, AIR 2003, SC 3057, it has been held that Section 175 Clause Subsection 1 Clause Q of the Haryana Panchayat Raj Act 1994, which disqualifies a person having more than two children from contesting election for the post of Sarpanch and Panch is not violative of Article 25 of the Constitution. The Muslim personal law permits a Muslim to marry four women, but it does not mandate him a duty to perform four marriages. Such a practice is not essential element of the Muslim personal law. Such practice which permit bigamy or polygamy can be regulated by law. The rule to contest election for any office in panchayats is neither fundamental right nor a common law right. It is a statutory right and subject to qualification and disqualification prescribed by law. If a person not fulfill such qualification, he can be prevented by law from contesting election for such post. Number 2. Regulation of secular and financial activities. Section 25 Article 25 Clause 2A provides that nothing shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activities which may be connected with religious practice. In Muhammad Hanif Qureshi vs. State of Bihar, AIR 1958, SC 731, it was held that slaughter of cow on the Bakri Eid was not an essential element of the Muslim religion and hence could be prohibited by law. Number 3. Social reform. Subclause B of Article 26 provides that the state is empowered to pass a law providing for social welfare or social reform on the throwing open of religious institution of a public character to all classes and section of Hindus. Article 25 Clause 2 State can eradicate social dogmas which stand in the ways of country's progress. In the state of Bombay versus Nurusu Apamali, AIR 1952, Bombay 84, an act which prohibited bigamy was held to be valid under Article 25 Clause 2b. Thus, where there is a conflict between the social need and religious practice, religion must yield. Matter of religion and secular administration. The freedom of religion is confined to only matter of religion, and the state can regulate secular and economic activity connected with religion. The distinction between matter of religion and those of secular administration of religious properties may at times appears to be a thin one, but in case of doubt, the court should take a common sense view and be actuated by consideration of practical necessity. In regard to affairs in the matter of religion, the right to management given to religious bodies is granted fundamental rights which no legislation can take away. On the other hand, as regards the administration of property vested in the religious denomination, its right to administer such property is subject to restriction that it must be exercised in accordance with law. In Ismail Faruqi vs. Union of India, 1994, 6 SCC 360, the Supreme Court has held that the state can, in exercise of their sovereign power, acquire place of worship like mosques, churches, temples, if it is necessary for maintenance of law and order, and such an act is not violative of Article 25 and 26 of the Constitution. The right to worship is an essential element of a religion, but right to worship at a particular place is not an essential element of a religion. So that's all about religious.